and I will be moderating the conversation today. Just to indicate that these conversations that we are having are really part of the capacity development work that is being done to support the creative sector, in terms of producing things, ensuring we have a policy environment that supports the sector, ensuring that the sector is able to grow and thrive through monetization and distribution, the utilization of various platforms that exist, and also recognizing the challenges that have been presented to us through COVID, and how we can mitigate those challenges. I'm also very happy to state that this work, the capacity development work, is being done in collaboration with the Kenya Copyright Board, KECOBO. And I want to recognize the presence of Paul Kaindo, who is with us today from KECOBO, to be able to respond to any questions that relate to KECOBO. And that this is not the last meeting that we are having. We will have very many other meetings. We have had meetings building capacity. We'll continue having meetings building capacity, as well as clarifying certain policies and regulations, challenging those that do not facilitate the growth of the sector, but also celebrating those that support the sector. So for today, we want to focus on monetization, assignment, licensing, the whole question of how we can create resources, how we can create some wealth through our work. And we have really a team of facilitators that have worked with us before in the previous meetings. We have Deborah Wanjogu, who is an IP lawyer, and we have Liz Lenjo, who is an advocate of the High Court of Kenya and also an IP lawyer. Both of them have been working with us on these issues of copyright and intellectual property rights and so on. They are part of the sector. They are very committed to the sector. They understand the sector, and they are available to support us whenever we request that they support us. So again, Deb and Liz, really welcome to today's meeting. So we really would like to start on the opportunities that exist for the sector to monetize. And maybe the way we will do this is to start with Deborah's reflections on this question of monetization, and then Liz can step in on the policy gaps and the policy opportunities also. Then we can have an interaction after both of you have had an opportunity to share your reflections on this topic. Again, just to say that we try to support the sector because we believe in the sector. I mean, we know that the sector has huge potential, a potential that has not been sufficiently exploited. So we do need to keep insisting that the sector is central to our economic and social transformation, and actually even our political transformation as a country, so that we pay attention to it. So maybe Deborah, you can start us off. Already, you can invite your colleague to step in, and then I'll come back to engage a little more with you. So Deborah.
Thanks, Prof. Thank you for this opportunity once again. And also thank you to KECOBO for this opportunity. The question on music, the digital exploitation and the rights that exist is very wide, and it has a lot to do with stuff that's not necessarily legal, because it's a business. Now you're talking about the business side of copyright. And that's where that whole element comes in. So you'll find that this conversation, and particularly the reflections that I give, they'll have very little to do with the law, but they'll speak more into the business side of things. So one of the things that I've seen is required when it comes to the opportunities, spotting opportunities and exploiting them, it has to do with the skills that you have. Yes, you're a good musician, you're a good instrumentalist, you're a good producer, you're a good whatever it is that you do, but there are other skills that you need to partner with, so that to partner your musical skill with, so that now you're able to take up as much of the challenge, the business challenge that comes your way. Some of those skills have to do with marketing, analytics, particularly analytics, because you need to know what people are liking. You need to be on top of what the trends are globally, with your own channels, with your own audiences, and even with other people. So sometimes you'll have to engage in some competitive analysis. Sometimes you'll have to just try and research on new topics to do with the music industry. And so that's where analytics comes in. You'll have to engage in stuff like market psychology or buyer psychology, because now you need to understand what is the thinking. By the time somebody is coming to click my song or my YouTube page, what is it that they're thinking? You'll have to understand what is called the social media pyramid, or the pyramid of social, because it will help you understand when somebody is on Facebook or Instagram or YouTube, what's their mindset, as opposed to when they come to your website, when they go to a news channel to see your stuff, or stuff like that. So those are some of the things that you'll need to look into. Obviously, you've heard a lot about branding, so I won't belabor that. And also something to do with audience cultivation. One of the things that has come out in the out of COVID is that many artists abroad, or who are performing to audiences abroad, are doing well because they have audiences who have been cultivated into giving. So when you have an online concert and you tell people donate, you'll find lots and lots of people donating, because they've already been cultivated into that culture of philanthropy, into the culture of donation. They've understood the cycle of the artist, that sometimes things won't go as well as they should. And particularly right now in the COVID season, they get that the season locked down a lot of festivals and performances. And so in order for artists to be seen and perform and earn their living, it's important to give. So when you're dealing with artists, or rather audiences abroad, it's not so much of a struggle. I won't say that it was 100% failure here in Kenya. It's just that it hasn't taken off as well. And that's because of the audience cultivation. And so this is one of the things that we need to get into as we discuss and think about opportunity spotting. Having said that, there's also the element of how to now tap into that digital space. And one of the things I've discovered from my research is that people are partnering in interesting ways. So say Liz has a page, she's a well-known DJ, or she's just very good at drawing audiences to herself. So she has this page which has, like, say 10,000 likes or 100,000 likes. And she'll host a virtual concert, and she'll host me on one day. And on that day, you'll have your pay bill number or whatever it is, that you'll have a PayPal account, something that people can donate to. As the concert is ongoing, you'll have a live chat that people can engage with. Guys will host parties in their own homes and post pictures and experiences as the concert is ongoing. So those are some of the things that have come out of this, and it points to the element of now partnerships that are symbiotic towards growing digital opportunities for artists, and in this case, musicians. Another thing that came out is the growth of streaming and the importance of how local platforms are dominating the scene. So you'll find that Spotify, yes, has come, but it may not be doing as well as Mdundo, because Mdundo has been around for a much longer time. It has established itself and it has a greater base. The same applies to Boomplay. So Boomplay will have a lot more reach, particularly depending if you want to go to Tanzania, you find that Boomplay is doing so much better there than other areas. But Spotify is still growing. It's still growing and it's trying to catch up with these other platforms. However, that doesn't negate its importance, because you still have international audiences and you want to reach everyone everywhere. And that leads me to the next point of distribution, which is now talking about how do you get your stuff on different platforms at the same time. What I've had people saying over and over, the industry players, is that there are two distributors they work with a lot. That is Believe. Believe is a French company, and then there's Orchard Distribution, which is American. Once you upload your stuff there, they have already formed partnerships with different streaming platforms across the world. So it's not just Spotify or Deezer or the ones which are already known. There are many others, even the ones that we don't know, that they have partnered with, and they will grow your business based on that. That does not say that you shouldn't market or do your own aggressive growth. It's just saying that they will ease that element of having to enter individual contracts with each and every single streaming site that you meet. Once you join that distribution platform, you'll find it so much easier to now get a larger audience. And then you'll be able to now understand, where does my music sell better, who listens to my stuff, which platforms work better for me. And then now from there, after those analytics, you'll be able now to grow your business. So I think for now, and one other thing that came out from my research and discussions with industry players is also the growth of individual platforms. So you'll find that, say, let's say Kelvin Isaiah here has released an album, and he wants to get 100% of the sales. He'll just open up a website with the name of that album, or whatever he wants to call it, and then sell. And then when on his YouTube page or link, when you go to that song and you listen to that song, you'll find the download link there. And so it will always direct people to that page where they'll buy their album, and they'll have a one-time download link. And that ensures that Isaiah will get his money, 100% of it. And also the audience will get a one-time download link, which means there's some element of protection when it comes to one-time distribution or downloading of that product. You won't be able to download it more than one time. So those are some of the things that I have picked up. There are others who are selling their stuff on WhatsApp. So it's an interesting space. Then one of the things that others said is that live performances have been affected, obviously. So now that's where the element of virtual performances and partnering with other people has come in. So I'll pause there for now. Liz, you can come in and say anything, and then Prof, I'll hand over back to you.
Sorry, for some reason, my internet was looking a little shaky. I hope you can hear me.
Yes, we can.
Okay, thanks. So I like how Debbie just sort of eased us into that whole scope about distribution and monetization in the digital space. I mean, just to add on, it's just to always remind rights holders that That's always important to remember the kind of rights that you have under copyright. And just for me to be a bit technical, but just reverting to section 26, in terms of the rights that usually are recorded under copyright. This helps also identify the different, should I say, revenue streams and opportunities that are usually there when it comes to distribution and monetization of your musical works or any other copyright works in the digital platform. So like one of the things that I think we always forget is about like translation, for example. If it's music, you're able to even find opportunities to collaborate and someone else can do a translation of your song. It could be a lyric video. It could even just be even an audio with someone singing in a different language, your song and things like that. And I think that's why, especially like when we're talking about musical works, publishers tend to come into play and assist to that process. So that then you get ahead of such opportunities. Again, with the gray area around parody and pastiche when it comes to copyrighted works, with that opportunity, you're able to also get ahead of it and still, be at the forefront of that distribution and the translation of the works. I think that's the one thing that I really wanted to add. So as we talk more about the other topic, other subtopics in this conversation, so that I don't preempt, but it's always important that we always remember these particular rights because they always open up those opportunities in terms of the distribution models, the distribution opportunities that we have in the online space. Thank you.
Yeah, and if I could just feed into that, it's just to say that this training is a build-up of what we discussed last time. And in the last section, we discussed a lot to do with the rights that each person holds within the music sector. So if you weren't present at that training, I'd encourage you to go to YouTube. I believe it's already been uploaded, and you'll be able to see what rights exist and where you fall within that ecosystem. And then you can now begin to draw out or map out the distribution or exploitation models that exist for your particular subsector. Yeah, thanks. Over to you, Prof.
Thank you very much, Deborah, and thanks a lot, Lizzie, for that. Very, very important intervention. And I really like the idea that we have to constantly learn. We have to continually learn so that we can become better. But I have a question, and I'll start with you, Deb. So there are these skills that the artist needs to have. But as a creative, sometimes, it can be very difficult to be a one-stop shop for everything. And because, you see, for instance, for me as a writer, when I write and I finish, I feel like I don't want to go back now and start chasing, other things. What type of partnerships does a musician actually need to have to make sure that they are at least, making some money? Because if there's, or is it possible for them to create and then pause and go collect their money and then come back and create again? I mean, and is that not disruptive? And especially because of the spaces that they're using, the digital space. So what advice would you give here in terms of the type of partnerships that are required to maximize on the product that the artist creates?
Thanks, Prof. That's a very important question, and it's an issue that disturbs artists across the board, not just musicians. When an artist creates, they don't want to have to think about the business of their art. Unfortunately, if you don't think about the business of your art, then how are you going to get the money that you want to, which will motivate you to keep creating? It's not to say that the only reason you're creating is to make money, but money is an important reason why you're creating what you do. So it's a catch-22. And I remember when I still had my business, my jewelry business, that's something that I struggled with, because on the one hand, I want my stuff to be known and I want to make money off it. But at the same time, the professionals that I needed would have cost me an arm and a leg, which is money that I didn't have at the time. So I didn't know what to do until I came across somebody who was a middleman, so to speak, and he was able to buy my stuff wholesale, and sell it off online. At the time, Facebook was just beginning, and he managed to do a good job of just, taking care of all that and taking that headache of mass sales off my hands. And so for me, what I've come to learn is that there's the tech element where there are apps and technical solutions that people have come up with to help artists deal with some of the admin and the business elements that they need to handle. Because as you're starting out, for the average person, money is going to be a challenge. So as you begin when you start off your business, how are you going to manage your time? How are you going to manage appointments? How are you going to manage distribution? How are you going to manage posting? All those things. How are you going to manage your accounts? There are apps that can help you manage all those things. For example, Hootsuite will help you post your stuff online. You'll have an app that can help you, like Calendly will help you schedule appointments. You have something like, I don't know, there are other apps, basically very many apps that will bring together several elements of your business and help you streamline how to run a one-stop shop, Then when it comes to the middlemen, I mean, you may have to consider working with a middleman, whether it's an artist manager or a distributor or a promoter or whatever it is that you need, so that they can now work with that, they can now push your work. But remember, if you work with a middleman, they're going to take a cut of your money. And so you're going to get a smaller percentage. So you just need to weigh what are the pros and cons for your personal, for the journey that you're on, and what would you like to do. Percentages vary. For Believe, I've seen that on their website, they say you pay an annual fee or a one-time fee annually, and then they hand over 100% of the money that you earn. They hand it over to you, 100% of it. For Mdundo, they'll take 50% of the cut. For someone like Ngoma will take 20% of the earnings that you make. So it all depends on what you want and what you're seeing. The website that I mentioned on selling an album, that is something that actually happened. And that artist made a lot of money and they kept 100% of their earnings. But at the same time, they had been building their base. They are a well-known band. And if I said their name, you would all know it. You would most probably recognize them. But you see, now they had the advantage of having done that legwork much earlier, so that by the time they were releasing their album, they could do that whole, we'll keep 100% of the money. So it all depends on what your strategy is and what you want to achieve. So I don't have that, there's no one clear-cut answer. It's all about working over and over again with your strategy and evaluating and reevaluating what you think will work for you at the stage that you're in.
So I think if I hear you, it's the importance of developing a business plan for the creative product that you have, and later I will ask you if, for example, I develop a film and I've invested in the development of this film. If I take it to Believe, they will sell it for me. So I pay an initial amount for do and they give me 100%. But how do I guarantee, that I actually get my money back? But I don't want to ask you that question now. I will ask it later, just in case Liz has a comment to make. And Liz, when you make a comment about that question of the artist being, building partnerships, maybe you could also reflect on how artists can manage the potentiality of exploitation online. How do you protect yourself from being exploited online so that your sweat, really benefits you and that you are not exploited? You can just maybe reflect a little bit on Deborah's response, but also on this question of exploitation.
Okay, thanks for that. I liked Debbie's insight. It's always interesting to hear from a creative also who's empowered with knowledge on some of the strategies that they use. And so, just hearing that for her, reliance on apps was something that she was keen on is very good to hear. You find that sometimes creatives are like, it's just too much work. So what we do is we also try and empower them in terms of understanding how teamwork should work, right? I'm a great proponent for teamwork, for collaborations, and I always try to discourage creative entrepreneurs from what I call pekiako productions. You're trying to be everything. As much as apps can do so much, sometimes you might find you always want someone to bounce off ideas from. So we always encourage that open interaction with the possible partners or collaborators. For example, if you have an artist manager, always have that open door. Even when you're starting out, it's easy to have a contract where you have even agreed, what, I'm starting out as an artist, this is what I have. Perhaps for the first year, you might take 10%, but within a year, our revenue share might go up and you might take 20% or 25%. This is the initial plan we have, and I'm hoping that you as my manager or you as my distributor, this is the plan that you would have. So that again, it's also agreed upon. The challenge we also have is usually that we're very abstract with some of these demands that we have or the aspirations that we have. So then we do not sit down and actually put them specifically and say, if it's a music publisher, this is the following that I'd request of you. One, I would like to see a marketing plan. What are the kind of distribution platforms you want to work with? What kind of threshold would be required? You need physical meetings, that whole thing, because at the end of the day, also this revenue that they will share in has to be justified. You're not just getting revenue for the sake of getting revenue. So it's always about having these conversations beforehand, having the contracts, and sometimes it might not be even, you don't just have to be a contract from a lawyer. It could even be minutes from a meeting that you have amongst the two of you, and you sign, and everyone has a copy of these minutes. So again, in this instance, you find that there are also those remedies in which you can also empower yourself, you can empower your team, and then eventually you say, okay, you know what, when we make some money, let's now take it to step 2 and now go and see a lawyer and see if everything we have done so far is good. What can we do to improve our relationship? So that again, it's a step-by-step approach. I think, unfortunately, sometimes creatives get overwhelmed with some of these things. So then they imagine it's too much to bite. But when you break it down, as Debbie said, having that business plan, again, it's also very easy to identify the different strategies or other steps. So we say, this is how we work, and sort of have building blocks. I think that is very important. When it comes to protection online, how do you protect yourself? I think first things first is always to remind copyright holders and creatives that IP copyright is a personal right. it means that it is in your hands. It is up to you to also ensure that you police your work and you protect your work. So which means that all these opportunities that you have identified and engaged in, the distribution, contracts that you might sign, all these parties that you might engage in, it means that you really have to have a proper accounting book where you are aware of where your work is being exploited. And as such, you are able to also police, if you have a manager or you have a team, they're also your eyes. They're your eyes online. And I think we'll get the opportunity to talk about this with another question, but there'll be the use of metadata, for example, what we call digital rights management information. That is the information that is used to sort of package your work in the online space, so that when I do a simple search, I'll be able to find, say, for example, professors' lectures online, because I have seen, there's some use of like metadata, some information that takes me to this particular work. So it's always important to have such, things that you employ. Again, with the strategy that you have, depending on the kind of content that you have, you can also employ technological protection measures, TPMs, especially, for example, if you decided that access to your work would be like a subscribership model, where someone has to pay, there is a paywall. So again, now these TPMs are what you really safeguard, so that then when someone breaks into them and sort of circumvents, already circumvention is an act of infringement, there's been trouble. And because it's a digital space, it's very easy to backtrack and actually trace how this work has been infringed upon. So I think that even with the kind of distributors and online platforms that you also engage in, that's the kind of conversations you want to have with them. What are their tracking mechanisms as well, so that you know that these particular parties, companies, or individuals are also in control of the situation, so that then if you're paying that one-time annual fee, at the same time, you're like, what am I paying for? I'm paying for them to also secure my work. I'm paying for them to assure that there is a clientele, that there's actually distribution that will happen and whatnot. So that is always important to be aware of. Again, I reiterate, protecting yourself and monitoring your work is always important. You have to literally self-police. Just like how you buy a piece of land and you're always aware who is on your piece of land. Have you put a fence? Did you need trees? Do you need an electric fence? Because maybe you're in a space where people will enter your space and maybe graze their cattle, for example. Things like that. So again, how you protect yourself and the strategies that you employ will depend on also the kind of space that you're in, and the opportunities that you see, so that at the end of the day, you might find that in another platform, the strategy might be slightly different from another because of such variances.
Thanks, Liz. So in other words, what you're telling us is that right from the onset, as a creative, we should not think that it's too much work to police that which we have created, and that if we are entering into any business deals, we try to have that documented, not verbally, but in some written form. And if, for example, we are holding a meeting to discuss the business potential, that we actually can be proactive in writing down the minutes and what we have agreed, because it is those minutes that then can form the basis for a contract between me as a creative and the person who is running my business. So that's how I'm understanding this. And I remember in the last meeting, you also encouraged creatives to try and seek the support of IP lawyers for guidance, and especially the contracting level, even if it's just reading through stuff. So I really want to thank you for that perspective. But before I move back to another question, how expensive, if, for example, I wanted to now enter into a business contract And the business entity generates the initial contract based on our meetings with them. How expensive is it for me as a creative to come to you and seek, kind of an opportunity for you to review the contract for me? Is it normally very expensive? I'm asking this on behalf of the creative sector because, we know how tough it can be, and the legal fees and so on. If you could just help us with that one.
So the good thing with services like contract review, contract negotiation, and contract drafting are not subject to what we call the advocate's remuneration order, which in some other services, there's a bare minimum that is set. So in that spectrum, there's opportunities to negotiate, there's opportunities to have a conversation. I always try to tell creatives, at the end of the day, if you can spend 5,000 shillings on your hair or 10,000 shillings on a pair of shoes, I believe you can plan yourself in a way that you say, I have 10 or 15,000 shillings set aside for legal. And you sort of have planned yourself and you're like, I have the following things that I would like. Let me go find an IP lawyer and negotiate. You see, the good thing is if you come with something, you're not empty-handed, you're much more appealing to work with. So that even the lawyer will say, oh, I actually like that. You're starting out. You put together 10,000. Apart from consultation, I might help you put together a split sheet and whatever other legal documentation that you may require. Lawyers are also human, so we can negotiate. It's not as expensive as you think. If anything, this is what we're calling protective lawyering. Sorry, excuse me. And by protective lawyering means you're coming before there's a problem. When you come before there's a problem, it's much easier to work with you, and the fees will definitely be very flexible. But if you come when there's a problem, when there's a matter in court, you need to file a case in court, you work from a point of ignorance, that becomes a whole lot more expensive because again, now with litigation, we'll have to revert to the ARO. So it's affordable. It's all about engaging. It's also about finding the right lawyer. I always tell creatives at the end of the day, talk to your peers, find out who are they working with, who have they worked with, so that, and I say this with utmost respect to my fellow learned people and friends, but you find that when it comes to IP, specifically to the creative economy, there's certain nuances, there's a certain way we need to package the law for the creative industry. We cannot apply it in that old-fashioned way. So you have to be very tactful as a creative in terms of finding a proper lawyer or a lawyer who will speak to your needs. Otherwise, again, you might get into trouble. Unfortunately, I've been in the position where I've had clients who had seen a lawyer who was not well versed with IP, and it's always heartbreaking to tell them, I'm sorry, but what you signed means you signed away your rights, and because you found a legal counsel, it shows that you did it from a point of information and knowledge. So unfortunately, we have to go back. You have to sort of come back, reinvent yourself, and then hopefully I can help you with your new project. It's very heartbreaking. And they never understand. They're like, no, but he said he's a lawyer, or she said he's a lawyer, and he knew. They say, unfortunately, there's an art to finding the right counsel. So for those who are here today as well, I'll tell them there's an art to finding the right counsel. Please do your homework. Talk to your fellow creatives and find out if they ever had a case, who did they use? Were they happy with their service? Because as lawyers, we don't market. We're not allowed to market. So it's all about our reputation and how we handle our clients. So always do that kind of homework, do that due diligence. It's like a marriage. So you want to find the right partner. Like you're finding a right manager, it's about finding the perfect fit. So I think that's what I would say. It's affordable. Please get it out of your mind that it's not inaffordable. Imagine the possibility of getting someone who will help you secure 100,000 or even $1 million versus you trying to secure 10,000 by yourself, because that's just the scope that perhaps you can see. So it's always about the bigger the pie, the more money you will still make, even if you have to share, So I think that's the kind of mentality that we need to have in the creative space.
Yes, thank you. Thank you very much. Again, I really appreciate this openness. And because I have you in the room, I really need to get into another question before again we open it up to others. If you could now go deeper into the digital rights management, and as well as the technical protective measures and so on. If you can go a little deeper into that, so that we can see how the creative sector itself can manage things online to protect again their money. And I really liked your illustration of how we protect pieces of land, because those of us who belong to the older generation, you're told when you buy a piece of land, make sure you plant a banana or you fence it, and that you also reinforce the beacons so you know where the beacons are and so forth. And I think it's the same principle really with the creative work. I mean, how do you own it? So you have created it, own it, protect it, make sure that it meets your needs. So if you could go now deeper into the measures as well as the management of that space, that would be great, Liz.
Okay. So and I use that land analogy always because as Africans, we know that we have always appreciated that land is the biggest form of asset you can ever own. You know, if you don't have a shamba, you're broke. So now as we have more IP sensitizations, we're telling people that also your IP is an asset. Your IP is your shamba. As long as you follow up with the right safeguards and make sure that you have the right beacons, right? Like in the last lecture, we talked about the registration of the copyright, why it is important. We also alluded to contracts, which we shall see them again here, why they are important, who is doing what, because of those parameters, those beacons. So when we're talking about the digital space, we have now what we call, like, for example, the metadata. This is the sort of information that you key in as you're uploading your file online. So as you're uploading, if it's music, you find people say they'll add words like genge tone, the name of the label, for example, of course, your name as an artist. Again, with the metadata, you have to always be very consistent. So if you have a pseudonym, for example, as an artist, then use the pseudonym. That's the one that should be, so that then you don't confuse people. I'm writing Liz with a Y when I put up in metadata, and then when I upload the work, I've put my full name, Liz Lenjo. So even the computer will get confused. Is it the same person? Is it the same property? So that kind of information is always important. We are seeing also businesses that are coming up, like for example, the music sector, that help also come up with codes. Unfortunately, I don't remember this organization, but I'll find it and I'll share it in the chat. But in the music sector, for example, there's this entity that Miss Angela Ndambuki now works with, and basically what they do, they give codes for sound recording. So if you're a producer, you need to have like the codes in advance, so that by the time you are even sharing this sound recording with the artists that you've been recording and whatnot, or uploading it, there's that digital identity. CZAC has the same thing when it comes to compositions as well, and all this is usually free. In fact, most of the time you don't pay because they are already well funded. So it's about identifying such information. If it's your book that you're going to put it online, you already got your ISBN number from Kenya National Library, so it should also be part of the metadata that you upload. If you had a book publisher as well, those are the kind of data that you need to have to sort of package your work, make it easy to find it, sorry, and sort of earmark it. So that's what we call digital rights management information. That's all that metadata that is around it, to trace your work, to know where it is, how it goes. And then now we have the technological protection measures. And this now mostly speak to the business side, which means, like, for example, now they are very popular now with the platforms, the distribution platforms, which will vary with the nature of business models that they have. So like when I said, if it's a subscription model, there will be the paywall. The paywall is a form of a TPM, a technological protection measure. So which means I have to either click pay by M-Pesa. When I have M-Pesa, I have access. It means if I put in my credit card number, then immediately I have access. So anyone who does not either key in M-Pesa or put in their credit card automatically will be guilty of circumvention, which is copyright infringement, then they'll be in trouble. Again, with the good thing with the software system and online, how it works, it becomes very easy to trace the action or the act and even the person. Sometimes the advanced criminals are always moving about and about, but at least with that kind of information, you also know what further protections or other TPMs you might need to. Excuse me, but those TPMs are what are important. So they will vary with the different models that you have. So again, in this instance, because they're mostly employed by the business people in the online distribution model. For you as a creative, it's about investigating. So how have you protected? How are you protecting my copyright, my IP in the digital space? What kind of TPMs do you have? And as you hear, then you also have prompting questions, because again, depending on the kind of worry that you have for your work, you're going to say, oh, so does that mean this file can't be downloaded, for example? Because we know, like, for example, on YouTube, nowadays, people have invented software that can actually download a video. And I have a personal copy on my phone or on my laptop. So you're able to ask, so what kind of TPMs have you employed in terms of, sealing that file and whatnot? So all that will vary with the different business models. The worries that you have as an IP holder, a rights holder, it's always important that you ask, so that then you also are aware. And if you've been exposed to something new or different, you're able to say, oh, but I think you should also explore X, Y, and Z, because we have seen this in another country or in another platform, so that you're also always engaging, if it is your distributor, if it is whatever platform it is that you're working with, and you have an engagement, you're able to interact and know what is going on. Again, with online platforms, especially when it comes to, say, for example, like the YouTubes, the TikToks, those terms and conditions are also important, because they will inform you what kind of measures that they have employed, so that then you're aware. Because once you're aware and you click accept, you cannot try and claim anything outside that contract, or what we call pop-up contracts, because they're a very valid contract. So again, it's always important to read that contract, you read that fine print, so that you decide, do I want to share my work on YouTube? Do I want to put my work on TikTok? Does it make sense with the business strategy that we talked about? Does it make sense with the IP strategy that I have? Does it make sense financially for me, and even any other opportunities as well? What kind of impact that has? So that's what I think I would say in terms of introducing also the issue of online platforms and the terms and conditions and pop-up contracts that arise thereafter.
Thank you very much. Thank you very much, Liz. I think this is so important, very important information, and also it's really looking at our creative products as a business. I mean, really, and that there are benefits that we can maximize on. Before we get to the whole question of policy gaps in our own case, I would like to ask Deb if she has any comment to make on what you have said so far. And then once she makes the intervention, I'll come back to you on the whole question of are we protected in terms of the policy for the creative sector as we work online, or are there things that we need to be able to pay attention to going forward, which can be a basis for more advocacy work for us, and so on. So Deb, you've listened to Liz, and I think she's made very important interventions on the TPMs and the digital rights management, and also all sorts of other important interventions. Is there anything else you'd like to add so far?
No, I think she's covered it quite well. I think the only thing that I'd really like to stress, which is a little bit further from what we had spoken about, is just the importance of the legal element, just talking to the right lawyer. I always say that when it comes to copyright and IP in general, all lawyers are not equal. And you see, going back to that analogy that she's given us of a shamba, this is at the very fundamental element. Everybody knows that for a shamba, you cannot just go claiming that the piece of land that you're sitting on right now belongs to you. You have to buy it first, yeah? But when it comes to copyright, the moment you've written that song, the moment you've played that melody, the moment it has been fixed and it's in a tangible form, you don't need to register it anywhere. You own that copyright. Copyright subsists and it's yours. So at that very fundamental part, that is why we keep stressing that all lawyers are not equal. And you need to go find the right lawyer for you. I know that this is not a fail-proof solution, but the Law Society of Kenya has different committees for different legal subsects. So you'll find that there's one which deals with intellectual property law and specifically copyright. And so if you find that you want to start knowing, where do I start searching? Go to LSK, ask them, show me which lawyers deal with intellectual property law. And they'll give you that list and you'll be able to now start asking around. When you're asking around, you have a base point. You say, okay, have you worked with Kimani Njogu? What sort of a lawyer is he? Have you worked with Joe Collins? What are your experiences? That way, you'll have a better starting point as opposed to just walking into. I promise you, if you walk into any law firm, they will say, yes, we know. And then they'll find a way of figuring it out. So, and then now you find yourself in those positions where you've sold out your rights for a song. So that's all I felt that I needed to stress on. And I'd also like to talk about, you had asked me a question on film distribution and how do you ensure that your rights are protected? Like for a platform like Believe is strictly for music. So another thing that I've realized is that as the industries progress, there are all these cycles that have been developed. And even when it comes to online exploitation, you'll find that there are different. One company will be able to focus strictly on that subsector. So you'll find that Believe deals strictly with musicians and it goes across the board. It will deal with the artist, it will deal with the producer, it will deal with the other smaller distributors. It deals with everybody within the music subsector. And so you'll find if you want to deal with film, you go to somebody who deals with film. So say Netflix or Showmax or, such people. So it's very industry specific. How do you guarantee? There are analytics and the system is always transparent. So you'll be able to see the activity that is going on in your platform and on your account. So by the time they're telling you we are remitting 80,000 shillings or the equivalent in whatever currency, it's because you'll be able to see these are the places they went, these are the streams they had, these are the advertising revenues that were attached to my product, and this is what my take home is. It's quite transparent. There's no room for games. So, yeah.
So let me ask you this, Deb. So they do the analytics for the music. How do I get to audit? Because you see, when you look at other businesses, people do audit the business. So if I was suspicious that I was not getting exactly what I should be getting as a musician or as a creative in whichever subsector, how can I do an audit of what I'm getting. I mean, if I get 10,000 shillings, but my gut tells me that I'm actually entitled to 100,000. Is there a system for auditing these things? I mean,
what I'm fearing is the wow. I'm looking for the softer word, but I can't find it. The psyche of Kenyans has been abused by all the corruption that we have experienced. And so whenever we go into deals and when we see people and platforms that exist, we always go with that mindset of the survival mindset where you're always expecting to be shafted in one way or another. And so you're always on edge looking for that. You're paranoid, perennially paranoid. Here's the thing. They don't have the time to rob you of 10,000 shillings. 10,000, even, let me put it in perspective. 90,000 shillings, your gut tells you should be earning 100K and they've given you 10,000 shillings. 100K is $1,000. $1,000 is pocket change. It is nothing in that industry. When you start dealing with people out there, you realize they're dealing in billions of dollars, not shillings, dollars. They don't have time to steal from you. They, in their space, they deal with delivering value. The reason Believe is such a big product is because they have taken time to invest in their skills, in their experience, in their expertise. They have to deliver value to their clients. They don't have time to start stealing from us. Yeah?
Haya, nimekusikia.
Yeah.
Nimekusikia. I mean, I am right there with the artist, because I'm on these platforms and I see all sorts of conversations about am I getting what I should be getting, and so on, you know. So yes. But does that apply across the board? I mean, does that apply across the board?
Well, I would say this. I would trust an international body, and I'm sorry, I would trust an international body more than I would trust a Kenyan body, because I know Kenyans, tumeipitia yote, we have gone through it and we know what to expect, or unfortunately, we've been programmed to expect certain things. Yeah. So even when you look at how CMOs are run, that already tells you that you're not quite sure whether you're getting your worth, you know. But when it comes to international bodies, those ones, they'll send you see that metadata that Liz was talking about. When you understand how analytics and data science works, you'll realize that by the time they're sending you your statement of account for a month, it was tabulated instantly. So there are no games, there's no time. They don't have that time. So what you're getting is most probably a true reflection of your earnings.
Yeah, thank you very much. And for those of you who are, metadata is basically identity. They are basically identity identity markers, so that if I go online and you know, if they are trying to find out how much they should pay Kimani Njogu, the name Kimani Njogu should pop up, and they should be able to tabulate that rather easily. Juakali, and so on. So it should be really easy to do that. So so that's important. And I think that we need to have faith, because we spend all the time looking for the shillings and cents that might have been lost. We minimize the possibility for creating more products. So in my conversation with the Nobel laureate Wole Soyinka, he told me that in Nigeria, once the creatives generate, you know, their product, they hand it over to a team that now markets it globally. And the minute they hand over, they go into the creative terrain. So they create, they pass it through the chain, through the channel, it goes, and they wait for the resources to come. And that way they are able to continue really creating a lot. I think that we need to imagine a different way. And before I bring in Liz, I have seen a question on the recordings of the previous conversations, just to indicate that these conversations are available on the Wabunifu platform, which we shall share. It's a website that we run at Shaweza Communications for the creative sector, and it's a space that is important for harnessing knowledge, making sure that whatever we create, that we are constantly learning, and if there are new policies, we also post them right there. So I'll put the link to the Wabunifu site in a moment. So Liz, can you step in, and as you step in, give us a perspective on the policy gaps with regard to monetization and distribution online, and if there is an opportunity for us to do advocacy work going forward. And then I'll now open it up for questions and comments from the rest of the team that's here with us today.
Okay, thank you. So before I talk about the policy and legislative gaps, allow me to just recap something regarding online platforms and the use of online platforms, especially when we are reading these terms and conditions. So these are some of the things that are always important for any copyright holder to pay attention to when they are reading these pop-up contracts. Because remember, when you say accept, you have accepted everything and you have presented that you have read and understood and you're aware, right? So it's always important to look at one, whether the nature of the contract is exclusive or non-exclusive, because that affects the nature of your distribution. It affects your ability to work with other companies and distributors from either other countries or continents. So always look out whether it's exclusive or non-exclusive. The second thing you want to look out for is the territory, because then again, you know, if you've locked yourself and what kind of territory you have locked yourself into. And then thirdly, you want to look at the IP clause, and the IP clause will include all those matters, including matters of takedown notice, what happens to your content when you discover your content was made available without your authorization, what kind of control do you have? Do you have any recourse? That's what the IP clause will talk about. It will talk about, you know, the responsibilities that this platform has towards your content. And then, of course, you want to look at the dispute resolution clause, because again, remember, with online distribution platforms, we open ourselves up to different territories. So depending with the party that you're contracting with, identify whether what law is going to prevail if there's an infringement situation. Can you defend yourself? What kind of resources would you need to defend yourself? So that then you make a pragmatic decision. And then, of course, the issue of conflict of laws, you know, what law is binding. With dispute resolution as well, are you going to mediate? Are you going to be bound to litigation? Always look for a platform that pushes for mediation as a first course of, or first instance in terms of, dispute resolution. Because if you're going to get terms and conditions where you're bound by litigation, that means if it was a platform where you're bound by the laws of the United Kingdom, you will need to get a lawyer in the UK. Can you afford that? If they're open to mediation, then it's flexible. You can get a Kenyan mediator with experience to assist with the mediation process with maybe this company based in the UK. So those are the most important things that you want to look out for when you're talking about the use of terms of platforms and their T's and C's and what they will provide for. So I hope people are taking notes. Now, when it comes to policy and legislative gaps, I have a list. And I think as a practitioner, it's because every time when we even pass amendments, you imagine we had passed what we had agreed upon in the beginning, only for you to discover that the amendments were re-amended under the table. So you find yourself in quite of a conundrum. So first, I would start with the issue, how we have covered takedown notices in the Kenyan Copyright Act. Unfortunately, it only covers the ISPs, the internet service provider. So the Safaricom, the Telcom, the Airtels, those are the people who are covered by takedown notices. However, when you look at the practice, especially in the US, which is where this practice of takedown notice emanated from and was borrowed from, it also includes content service providers, CSPs. So ideally, because of the nature of the kind of due diligence that a content service provider would have to do might be ridiculous. Because remember, when we're talking about content creation, if it's that song before it's released, there are so many parties who are involved. So for example, with a song, that means an online platform would need to ask for the split sheet, the contract with the sound record, with the label or the producer, the one who puts in the money. Please revert to that initial recording that we had because of that confusion. It means the contract with the music video producer. Can you imagine having all that? It's crazy, right? So ideally, CSPs should have also been factored in this situation, so that then the minute they are told, oh, I'm a rights holder in this song or in this form or in this film, and this is the nature of my rights, I was not consulted, blah, 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 please, immediately they can take it down, so they can suspend it. They will suspend any money that had already been generated, so that these parties can go back to court and they come back and share the ruling and say, okay, this is what we have been given by the court, or we settled out of court, here is our agreement, proceed to put back the content and share the money as outlined in this agreement, things like that. So unfortunately, as it is right now, CSPs are not factored in, which means the business model of CSPs is in a dangerous path. It could die anytime. It just needs one enlightened rights holder, and they can take down the system, right? Which also interferes with innovation in the entertainment space, in the content space. So we want to secure that and have at least some practical solutions. Because again, remember, when it comes to copyright infringement, when it comes to piracy, people are always very clever. Pirates are very clever and innovative. But at least when we have the basics, we have at least like a structure that's like a net. It might have 2 holes, but at least it's protecting some mosquitoes, some bugs, that kind of solution. And then as we use it, we are also able to see what other opportunities are there. So that is one of those gaps that we have. And then secondly, perhaps a minimal sort of policy or legal requirement for also now these content service providers to have in terms of due diligence, at least the preliminaries, right? Identifying the parties who are the specific rights holders and making sure that the CSPs have at least some sort of deposit mechanism where when I submit a song, for example, at least they will have a copy of the split sheet and they will have a copy of the sound recording agreement. Then they know they're paying the right people. And at least, it shows that they did some work, because then they're not so blanket and blasé with things and say, oh, hello, professor, I had this song with yours. Okay, sign here, No, I'd say, professor, show me the documents before we get into this agreement, right? I think that is something that's very important. Then another policy gap that we have is how we are handling agency law when it comes to the entertainment industry, when it comes to IP transactions, be it copyright, trademarks, across board. Especially because in the creative side, we have a lot of these middlemen, right, who are agents. So it might be the manager, it might be an advertising agent who has been contracted by a multinational or a company to sort of transact and get access to your IP, right? At the end of the day, because agency law is a common law practice, right? So it's a customary thing. So we are yet to per se adopt it in our Kenyan laws, in written law. So you find that even when we're in court, we generally, even in other areas of law, when it comes to matters agency law, we're always relying on common law. So I think it's now time that we wrote it down. We know at the end of the day, if, say, for example, my law firm used Debbie's song, right? Despite me using, say, Cindy as the ad agent, at the end of the day, I'm the one who will be bound. I'm the one who will be liable for infringement, because it is my brand that is riding on Debbie's intellectual property rights. It is my brand that is making the money. It is my brand that is being associated. So by you just, bringing in Cindy and saying, oh, but no, Cindy is the agent, she's unresponsible. An agent is simply and always liable for the parties of, the principal is always liable for the conduct of its agent. They're acting on their behalf. They cannot remove themselves. We need to figure that out. We need to write it in plain English. We stop wasting the time of the court. Where it is plain infringement, it is plain infringement. I think that is something we have to be very clear with. Having been exposed to cases in the US, they don't have time for these games, because at the end of the day, even a lawyer who is trying to employ such tactics, they're always found in trouble for malpractice. Their malpractice is much higher. Their threshold is very high, which is impressive. So I think we need to get there. We need to start saving time and money. We need to act in the interest of justice and fairness. So that is something that really needs to be looked into. I think we need to figure out, on my fourth point, how we ensure that we have infrastructure when it comes to some of these bills that are being passed that affect the copyright industries. We need to figure out a consultation measure before even this bill is tabled. Were there any perhaps signatures? I think let's say even at least in the 10,000s and above, where artists have been, the right holders have been consulted. Before this, we see these weird bills that are being tabled, like, case in point, what I'm now calling the Wanga Amendment Bill. It's trying to get rid of, take down notices. Does not make sense, right? It's trying to put in a legislative fashion what kind of ratios the revenue would be split between an ISP and a rights holder in terms of digital revenue. It does not make sense. That's a business conversation, and it has no locus in a piece of legislation. So consultative measures need to be figured out so that before they start passing on laws or bills that affect an industry they know nothing about, only assumptions and presumptions, we need that kind of mechanism. Then it also saves us the anxiety. When there's anxiety, there's less creativity and innovation. Our innovation, ability to innovate in the creative space goes down, because half the time you're like, so now if I innovate or if I create, the law is not helping me, or this law then means I will lose X, Y, and Z. Then people stop creating, and the economy sort of comes to a standstill. So that is something I think we need to look into. And then the employment of technology to monitor work. That is something that we might have to look into and see how it can be more fundamental, especially when it comes to Kenyan companies. As Debbie said earlier, the inclination to trust an international company is much higher than a local company. So we need to have such policy demands. We need to have training on blockchain in terms of how blockchain works and how it helps create that, I have to use the word chain of information, so that then you can see the downloads, the country, and blah, 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 so that you can, because this is the thing with blockchain. If I try to interfere with the information, the whole system might crash or whatever. Like there's a way they structure it. So it means that practitioners, business people in the creative space, perhaps they need to start, either licensing or creating their own also blockchain ways, because then it helps secure our IP rights, our copyrights in the digital space. That is something that needs to happen, and more knowledge about blockchain, for especially the business people in this regard, and also for the artists, so that they know how it works and they're able to see any, bad manners, for lack of a better word, when it comes to the use of their work. And then lastly, I would say we need to redefine the position of criminal law when it comes to, copyright infringement and IP infringement as a whole. Perhaps it's time for us to make it clear that, maybe define the types of fraud that can happen online, so that then it's very clear and very specific that there was fraudulent transaction of copyright works, so that then, it's also now covered in the criminal procedure code and criminal law, aside from all these other acts that we have, like the Computer Misuse and Cybercrimes Act, which is kind of struggling, right? But I think, when we look at the criminal law and criminal procedure, if we factor it in somewhere there, I think it might also give it some gravitas. So again, criminal activities around copyright, around IP rights, I think is something that we have to sit down and think through and see what kind of amendments we need in that regard as well. And I think those would be my submissions when it comes to the gaps that we have in terms of policy and legislation.
Thank you very much, Liz, for that. And I think that maybe next year we need to find out an opportunity to really discuss the blockchain issue, the whole question of the embeddedness of the various elements to make sure that they are not broken. So I think that that's something that we need to reflect on. And some of the issues that you have raised relate also to the centrality of public participation in all sorts of, in all forms of legislation in Kenya, because that's the constitutional path, that there should be no amendments to the law without sufficient public participation. And I think that the creative sector has a responsibility of pursuing these issues, because anything that goes and gets passed without sufficient public participation would be unconstitutional, really. And I think that the involvement of the sector themselves and to be able to be there when the decisions are being made is really, really critical. So Deb, do you want to make a comment, and then we'll just open it up now for additional comments from our colleagues?
Yes, thank you, Prof. I just wanted to speak from a general perspective, because I've realized that with respect to online copyright, for it to be respected, it means that the government needs to start taking the digital and online space more seriously. Already you can see the shenanigans we have experienced regarding Huduma number, regarding the digitization of land transactions. When you go to parliament, the things they are concerned about is who's the admin of a WhatsApp group so that they are fined for things that are shared. They don't seem to understand that when we are told the digital economy has generated over 200 billion Kenya shillings, it means something. And so where are the statistics? Where is the empowerment? What is CAK's role in all this? I feel like the government it's taking this thing so lightly that it ends up jeopardizing economies and livelihoods. And I believe because Kenya seems to be thriving on disruption, if the government had taken this thing of the internet and digital access more seriously, the economy would have recovered much faster, in my personal opinion. And I think it's time that the government becomes more proactive, even with its own employees, because they're the ones who will frustrate the digitization or adoption of digital stuff, because they don't want to stress themselves having to learn how to use a computer, having to learn new language. Their comfort ends up interfering with an entire system, an entire country's growth. So that for me is the biggest link, the weakest link being government. And then when it comes to talking about agencies, I agree, agency law, I agree wholeheartedly with what Liz has said. And even when you go to the Copyright Act, my goodness, they are talking about, back to our Shamba analogy, an assignment of copyright and licensing copyright are used interchangeably. Those words are not interchangeable, because an assignment is the equivalent of owning a title to a shamba. And a license is the equivalent of a lease, temporary ownership or temporary permission to exploit a shamba. So how are we now conflating them? It can't work. There needs to be proper, there have been calls for a complete overhaul, repeal the Copyright Act and just draft a new one that is more responsive to the current situation and is drafted by the people who are experts in that field. The stakeholder, it should reflect the needs of the the system of copyright and not necessarily protect in personal interests that are vested in a particular legislation at any point in time. So those are, for me, those are the things that I feel need to be touched on when it comes to policy and legislation regarding copyright, and particularly digital copyright. Thank you, Prof.
Thank you, Deb, for that very important comment. It reminds me of what we've been doing the last few days, engaging Nyandarua County for copyright infringement, where they put a lot of creative works on their website to drive traffic into their website. So they had Chimamanda's novels, Yvonne Awar's novels, Dance of the Jacaranda by Peter Kimani, all in PDF. And this, I mean, you can imagine writing a book for 7 years, and then it is found in PDF in a county website, because in my view, they are trying to drive traffic to their website. Of course, we did raise this matter up with Kekobo, and the Kekobo has picked up the issue. This is like over the last, 3-4 days ago. And I'm still waiting to hear what the decision is, because we took this very, very seriously. Because if the county government of Nyandarua can use creative works to drive traffic to their website, what else can't they do in terms of violating the rights of creatives? So, so thank you very much. And I think that it's, you know, I'm just underscoring the point you've made about the government taking copyright seriously. And I think that we should be able to do more work there, because we also know that sometimes the state uses copyrighted works without paying for it. You know, it's almost like artists need not be paid. So let's now open up for comments. I've seen a couple of comments in the chat. Maybe we can start there. Liz, do you want to respond to some of the comments in the chat as we wait for people? And remember, people, you can raise your hand if you want to make an intervention. I can see Michael Kamu has a question. I also saw another question related to CMOs. If Liz, you can respond to these questions. Okay,
so I'll start with first of all, I shared links to the specific organizations that have helped give identifiers on online platforms. So we have IFPI, which is for sound recording, and CZAC for the musical works, you know, in music, or rather the arrangements, the compositions and whatnot. So someone had asked, what is the equivalent CMOs at international space? So I'd like to comment by saying that each country have their own CMOs. And we'll find that what informs, especially like Kenyan artists to join a foreign CMO would be based on the exploitation of their work or their music and where they are most popular. So you'll find, like, for example, in the UK, because African music has become very popular there, they have joined the likes of PPL in the UK. They have also joined Samro. Samro is also very popular when it comes to royalty payment. We also have, Samro is based in South Africa. Then we have ASCAP in the USA, which is also known for that. And of course, also all these other countries, especially in Europe, are also appealing to our artists. So you find that they join there. So remember again that each country have their own CMOs, and even them, they try and market and make themselves known. So I think that's what I would make the comment. We have Paul Kaindo in the room. I think this question we let Paul on behalf of Mr. Sigei to answer. Paul, are you there?
Yes, Liz, I'm there. Thank you.
Yes, I believe you have seen the question.
The one on the CMO?
Yes.
Okay, I'll attempt to respond to the same. I think there were two, I've seen two. One by Martin Juki. And thank you, Prof, for having me today. At least it's nice to see you after a very long time. Now, Martin Juki asks, why does our CMOs pay our artists very little? What is Kekobo's heart in it? Can Kekobo save the artist? And when we started, I think I recall Liz saying that even artists, they have a role in ensuring that their copyright works and their collective copyright protection of their rights are actually in their hands as well. Now, of course, you have had over the last few days, we have been doing a lot in relation to putting the collective management organizations on their toes. These are matters that are before the court, so I wouldn't want to comment so much in them. And at some point, Kekobo actually went to court in its own name, and unfortunately, no artist has even applied in court to be enjoined as an interested party. So Kekobo is left to fight on behalf of the artist on its own. So I urge that the artist also take part in this litigation relating to collective management organizations. So I wouldn't want to comment so much, but Kekobo is doing a lot to ensure that the collective management system in Kenya works effectively for the best interest of the artist, because we have had historical injustices, if I would say so, where the artists have always complained that they're not being paid what they actually deserve. So there are cases in court. Creatives who are here, kindly follow them. Of course, they are at an advanced stage. And in court, because we have been asked, why is it that it is Kekobo only who is fighting for the right holders? It appears that the rights holders are okay with what they are getting. So Kekobo is doing its best to ensure that. Then the next question about CMOs was by Michael Kamunya, who asked whether CMOs apply to other forms of creative works like stage plays, films, or do these aspects need to form their own? Now, the Copyright Act allows collective management organizations to be formed in regard to each of the rights. And as we speak, there are CMOs which represent the rights of performers. We have those ones that represent, of course, stage plays, the performers in stage play would actually be protected there. Then we have collective management organizations who represent authors of music works. Of course, most of these CMOs are in the musical industry. However, it is also possible to have CMOs representing each of the rights. So if there is a right that is not represented by a CMO, the right holders have the right to come together and create a CMO. As we speak, there is no licensed CMO that represents the rights of authors of literary works. Initially, it was Copyken, but it has not been licensed. So the law allows for representation for CMOs for each of the copyright works. So I don't see another question relating to Kekobo, but if there is another one, I'll still respond. That effectively responds to the issues. Thank you.
Yeah. Because you are there. Let me ask you this question, because I recall we did a survey on whether Copyken should be reestablished, as it were, to represent the interests of literary arts or in writers and so on. And I think that those of us who are writers supported the formation of such a CMO. Is it possible to just, even if you don't comprehensively respond to this one, could you check what the status is? Because I know that I filled the survey, and I think that we did quite a bit of work to push for the registration of or the activation of Copyken. Can you?
Yes. Yes, thank you, Professor. I actually do recall that survey. We were actually involved. We received, and it is a work in progress. And effectively, there are a lot of proposals that came up. And when an advert was done, or when a call was done to actually call for persons interested to cover that area, actually we received very minimum, if any, of interested parties. So this is work in progress, and there will be efforts to probably revive CopyCan, but there are some legislative, policy issues that CopyCan needs to engage in, like they were asked to probably look into their memorandum of association to allow individual right holders and the like. So this is work in progress, and we hope we are going to have a breakthrough soon enough.
Yeah, let me just say that at the Creative Economy Working Group, we would be interested in this matter, precisely because sometimes we find ourselves struggling with the rights of writers, such as Ken Walibora and others, who who have made a huge mark, and then something happens and it's very difficult. So maybe next year, I think the message I would like to send back is, let us follow up this to see whether there is a way in which we can support, yeah, or work together. So I think this is good. Any other, and thanks a lot, Paul. Is there any other comment, Liz, in the chat?
I don't think we have any other question, but I wanted to just add something on the question of CMOs. And this is because we realize that most parties don't also seem to understand the rationale behind collective management organizations. And so for purposes of those in the room today, it's basically to remind them that CMOs exist for collective administration where it does not make sense for individual rights holders to claim or to administer their copyright. So especially when it comes to performance in public places or access to people in the public space. So, taking them back again to the history, it's CMOs came to be when authors and musicians realized that it was not going to be practical to walk into a bar and say, hey boss, you've played my song, give me 100 shillings. Can you imagine if that guy was to go across all the bars in Kenya? And all the discos and whatnot. So that's why CMOs exist. It's for that collective administration where music or their works is exploited in the public sphere. So even now for CopyCan for us is also very important because of the book industry and the fact that especially the kind of use that we have, the lack of access, because not all Kenyans can afford books. But because within that exception, we take away the author's right to earn, we get to license these photocopy places and whatnot so that the reprographic rights are taken care of. So which means that outside that, the right holders have the right to still directly monetize their work, distribute, make available outside this. So I think we need to stop also idolizing royalties and CMOs like they are the alpha and omega in the ecosystem of copyright, right? They are only a very small fraction. Then the rest of it, the power lies in the rights holders, in the authors, in the composers, in the the stakeholders in terms of the copyright ownership. I think that's always important to bring back. And then secondly, it's sad to hear that no other company or interested party wanted to register a similar CMO. Because I know, I think for CopyCan, because their greatest challenge was that their rights holders are the big companies. They always have bigger fish to fry. So of course, the detriment of the independent writer. So I'm hoping that in this coming year, we will see the independent authors come together and register their own. And then what they can do, they can still be flexible and say, if you do not want to be part of CopyCan as a publisher, you can have the opportunity to join ours. Move join the vehicle that will move and take you to the next train station or to the next destination kind of thing. Because otherwise, if you're going to wait for CopyCan, we'll really wait. And already they have lost so much in the last couple of years. And yet the book industry is one that is very active, very lucrative, and is really thriving in Kenya. Yeah.
Yeah, and because I have you, Liz, so I am a member of the Creative Writers Association of Kenya. And I think that, so it's a registered association. It's an association of writers of creative works in the country. Is this a conversation that you think we should also be having with the Creative Writers Association of Kenya next year?
Most definitely. And especially if they're more organized, we might see a call to action. I think also another challenge is that the sensitization for the new age writers is also still lacking, because I think we always forget that the rights holder pool is growing. So there are all these now new players that are getting into the market, into the game. There are these new, millennials that have now grown into adults and they're writing. There's also children we have who are now authors and they own copyright. So which means also their guardians need to be engaged and sensitized. So I think it's time we had these conversations. And then from that level, now we even start educating, private universities. We start with them because we know the challenge with public entities, but we start with them because if we compel them, or rather if we educate them and help compel them towards respecting our IP rights, our copyrights, then we'll see better compliance without a doubt.
So this we're building momentum for more discussions next year, because really, again, it's the complete commitment to ensuring that those who work in the creative sector benefit fully from their imagination, their creativity, and so on. And because I can't see any hand up, maybe just give Deb 2 minutes to make her concluding remarks, and you, Liz, you can also make your concluding, and then we just wrap it up in the next 5 minutes. Deb.
Thank you, Prof. I'd just like to thank you all for attending this session. I mean, it's very important and encouraging for us to see people who are interested in understanding the legal aspects and of their business, because there's a lot of noise out there. You keep hearing content is the next big thing, but what does that mean? And it's very encouraging to see you guys showing up. Please keep showing up for these trainings wherever they are held, whether it's by Kekobo or any other institution. Please keep building yourself up, because that's how the industry grows. The Go Down has a course which it teaches, allow me just to do this plug, on an annual basis. I was privileged to teach it this year with Liz. It's called Copyright X. It's annual, and it's a partnership between Harvard University and the Go Down Arts Center. You get to understand what American copyright law looks like with a comparative study on Kenyan law and a few other states around the world. And so we'd like to encourage you, whenever you see that call, please come in. It's intense, it's 12 weeks, so it's like a full semester. And you're going to be taught like lawyers, but don't worry, we shall break it down in a way that will help you understand things in it. Like we teach it as though we are not talking to lawyers. So don't be intimidated by it, and please join it whenever the call comes. Apply for it. So thank you very much for your time. I'm very privileged to have spoken to you, and I look forward to engaging with you guys in the future. And thank you to Prof and Kekobo for this opportunity. Thanks.
Thanks, Deb. Liz?
I also firstly would like to extend my gratitude for this invitation. I think I'm happy to always see that every time we have such events, we will always have people present, and new people and new parties that are hungry for this knowledge. So for those who are here, congratulations, and thank you for coming, because you invested in yourself. You've saved yourself money. This is the kind of service we charge premium for if you walk into my office or any other lawyer's office. So I'd like to encourage that you tell your friends also to continue attending such events, invest in yourself. They are free for a reason, because we want you to know more about the law. You know, we want to tell you and educate you more about the health status of your creative business, so that then you know when you're ill. You cannot know when you're ill if you do not know what it means to be healthy, you know? So that is the primary reason why myself I do this, because also the more enlightened the creatives are, the more business I will get. Otherwise, we are not doing anything. And then of course, a primary reminder that your IP is your shamba, your IP is your car. There is no way you would buy a fancy car and then give it to a third party to drive, you know, for those who like fancy cars, you know. So be in control of your intellectual property. When you're investing in yourself, at least you're educating yourself in the preliminaries. Like we said earlier, we're not trying to make you lawyers or accountants or marketers, but we're giving you enough information so that you're able to call a bluff when you see it. When someone is trying to misrepresent their skill, you can see it. Don't wait until the ship has sunk and then you say, Liz lied to me. No. It's about you at least knowing the key indicators of what a healthy creative business looks like. And then you can hire and fire based from a point of information. So all in all, thank you so much, Prof. And Kekobo for hosting this. We look forward to working together again next year and realizing all these gaps that we have. There is so much money the creative industry and sector is hemorrhaging, and yet we have the power in our hands to make sure that we catch up. So I am humbled and I am thankful, and I look forward to many more. Thank you.
Thank you very much, colleagues. This is so important, and really to thank everybody for this work. At Traweza Communications, we will continue, supporting the sector, not just because we are an arts, culture, and media institution, but also because we also generate content. We also generate creative content, and so on. And therefore, we are also invested in this. We are part of the sector, and we will continue organizing this with various partners. I know that we have scheduled also something with the Kenya Film Commission. We have scheduled some other activities with Google for the sector. We have scheduled other activities with the Department of Culture. And of course, we'll continue collaborating with Kekobo to, again, build capacity. So it's very, very important that we do this work. And remember, knowledge is power. If you don't have the knowledge, it's very difficult for you to claim that which belongs to you. So, this constant enrichment, constant seizing of opportunities to learn is really, really important for all of us. So again, Deb, Liz, I want to thank you very, very much. Let's continue working together. We will always be calling on you to support this growth of the sector. And thanks for creating the time to work with us. So colleagues, that's it. The recordings, all our recordings are available at the wabunifu.org platform. So once it's assembled, it's put up there, and you are able to pick it and to learn consistently from it. So God bless you. All the best. I hope that we can meet again before Christmas. I think there's something scheduled before Christmas. I will let you know when that happens. So all the best, and thank you. Thank you.